May it please the court. My name is James McCartney, and I represent the appellant, Female Inc., in this matter. I would like to ask to reserve 2 minutes of my time for rebuttal. Thank you, Your Honors. Female Incorporated respectfully asks this court to reverse the trial court's decision in granting the plaintiff's motion for summary judgment. The issue before the court today is whether being of the female sex is a bona fide occupational qualification for a Chicago-based taxi company whose sole mission is to provide the best possible sense of personal safety and security to its customers. Your Honors, Female Inc. will clearly show that being female is in fact a bona fide occupational qualification for employment with Female Incorporated, so that the business is able to continue serving its customers whom the appellant has set out to serve in their community. In order for an employer to establish a bona fide occupational qualification, I'll call that a BFOQ here for the sake of economy of words, there are 3 elements that must be met, and Female will show that all 3 have in fact been met. The first, which we will review here today, is that there is a factual basis for believing that hiring any members of one sex would undermine the essence of its business. Element number 2 is that the asserted privacy interest is entitled to protection under the law. And 3 is that no reasonable alternatives exist to protect the privacy interests other than gender-based hiring. Now, a brief recitation of the facts before I dive into our arguments here today is that I'd like to point out 2 exhibits in particular in the record, exhibits B and C, as they are the individual testimonies of Brittany Tiergarten and Marcella Farrell, 2 customers of Female. Now, Female Inc. was established as a taxi company in Chicago so that passengers, particularly female passengers, to be provided a sense of safety in their daily commutes to and from work or personal events by female-only drivers. The targeted clientele were those individuals of the female gender that had been assaulted or felt unsafe in the presence of exclusively a male. In Exhibit B, Marcella Farrell points out that she worked for a bank in downtown Chicago and was sexually assaulted when she was on a date in college. The man that she was on the date with took her out on her date, and on their way home, he drove. He sexually assaulted her in the vehicle and then kicked her out of the vehicle, leaving her on her own after she was assaulted. Now, it was also found out in that particular matter that this individual had given a fake name, fake information, and was unable to be located by the police. Ms. Farrell found that she would have panic attacks and was not able to be alone in a car with a man without having such panic attacks. She later found that the only way she was able to comfortably enter into a taxi was with a female driver, so as to avoid the threat and the feeling of assault from a male driver. Similarly, in Exhibit C, Brittany Tiergarten is a woman who testified before the court in noting that when she called a taxi from her law firm office and also in downtown Chicago, she received a ride from a male individual who then in the ensuing days proceeded to stalk her by remaining in his taxi outside of her apartment and following her and tracing her whereabouts for the next days. In contact with the police, since this individual had not done anything that broke the law, they were unable to act and do anything to prevent this male from stopping. So she found that using female taxi services alleviated the concern of a male stalker and prevented those concerns from creeping in. Now, diving into the essence of our argument here today, we know that Tyler Gill had completed an application for employment with female on September 16th of 2021. The following day, on September 17th of 2021, he received notification that his application for employment was declined because he was a male. Now, the Civil Rights Act, it states specifically that it shall not be unlawful as an employment practice for an employer to hire and employ employees on the basis of sex in those certain instances where sex is a bona fide occupational qualification reasonably necessary to the normal operation of the particular business or enterprise. As I stated before, there are three elements needed in order to establish that a business is exempt from Title VII of the Civil Rights Act. And the first that I'll dive in here today is that there is a factual basis for believing that hiring any members of one sex would undermine the essence of its business. And female will prove that hiring males would, in fact, undermine the essence of female's business. Now, I think it's critical here to note, it is critical here to note that 85% of Female Incorporated's customers are female, and they use its services specifically because the drivers are female. As per the Sedita case noted in my briefs presented to the court, a defendant in a privacy rights case must satisfy its burden of proving a factual basis for sex-based hiring by showing that the clients or guests of a particular business would not consent to the service of the opposite sex. And that is exactly what we have here today. Given the fact that 85% of females' clientele use its service specifically because it utilizes exclusively female drivers, absolutely would undermine the business, because that's the exact and specific reason that its clientele chooses to patronize and use its services. Furthermore, I think it is critical to point out the difference in notable cases also documented in the brief submitted was the Diaz versus Pan Am case. While not from our circuit, it is critical to note, as it's a well-known case and adhered to in a number of jurisdictions, that a male flight attendant applicant put an application in for employment with Pan Am. They rejected him on the basis of his being male, and the court ended up deciding in favor of Mr. Diaz. Now, the reason for that was in the Diaz case is it was noted that female flight attendants perform the non-mechanical aspects of the job to better satisfaction of customers across the board than males did. The court did rule, however, that while they approved of these or noted that the non-mechanical, more tangential aspects of the jobs were performed better by females, it was not appropriate for the airline to continue to hire based on those aspects alone. Those aspects were deemed inappropriate as a basis for hiring. And in our case, we have something that's very dissimilar, and that's why that case is cited here, is the non-mechanical and tangential tasks performed by those airline attendants is fundamentally different from those tasks which are provided by the female drivers at Female. What is being performed at Female is the providing of a sense of security and a better sense of personal safety in the traveling experience that the customer has in the back of the taxi. It is not the case that they're performing some tangential aspect of the job. They are performing the essence of the job itself, which is getting someone safely into their taxi cab, driving them safely to their location with no presented or posed risk of sexual assault by a male. If it were the case that a male were permitted to work for Female Incorporated, that would entirely undermine both the purpose of the business and the primary reason as to why patrons utilize its service. Next, the asserted privacy interest is entitled to protection under the law. That's element number 2, as I noted previously. In the Norwood versus Dale maintenance systems case from our circuit, it is noted that those occupations which require an employee to work with or around individuals whose bodies are exposed in varying degrees are entitled to protection under the law. Now, that case did note and pertain to individuals that were cleaning restrooms of the opposite gender. While it is the case that in that situation it is possible to be exposed to the human body in a nude or otherwise personally exposed form, what we have here is not necessarily different. And what I mean by that is that the individuals that are utilizing female services are using its services to obtain a female driver because they feel that in an environment with a male driver, they would be exposed either to sexual assault, to possible stalking, or some other negative consequence of the interaction with a male driver. Furthermore, the court had declined to comment in the Sedita case, also submitted, as I mentioned previously in the briefs to the court here, that customers do not have a protectable privacy interest, or they did not, or they chose not to comment on whether or not customers have a protectable interest of privacy when their breasts, buttocks, or inner thighs are to be touched. That was left open by the court to be interpreted, and I think our case, and it is the case that our case falls into a similar scenario given the background of the individuals that utilize female service. Additionally, in element number 3, no reasonable alternatives exist currently to protect the privacy interests of the individuals utilizing the service other than a gender-based hiring system. That is absolutely the case here. There are no available alternatives in the present moment in time where a female passenger who is seeking a female driver for the purpose of greater personal security and personal safety that would impede or prevent a possible male assailant from harming them. It is possible that cameras could be used, or there could be plastic safety shields inserted between the front and back passenger seats. Those do not eliminate, however, the risk posed by potential male assailants against female passengers, nor do they provide an enhanced sense of security in the fact that they could be removed, they could be discarded or destroyed in some fashion that does not in any way enhance the protection of the female passenger. Your Honors, I see that my time is running short here, so I'd like to conclude with noting that female is able, as documented in the briefs and presented here, that they are able to establish all 3 elements required for an exception to Title VII. Thank you for your time. I appreciate your listening, and I'm happy to take any questions that you might have. Thank you.